Hello everyone! It has been weeks since I haven't been posting our criminal law review because it's Christmas. And now we are so back in the game. So let's begin our review for criminal law. To start with, University of Santo Tomas Criminal Law Review Pre-Week Notes of 2016 Part 4. Okay, for our topic for today is crime against public interest. The first category is forgery. How is forgery committed? This was asked in 2008 bar. Okay, forgery is committed in 1. By giving to a treasury or bank note or any instrument payable to bearer or to order mentioned therein the appearance of a true and genuine document. Number 2, by erasing, substituting, counterfeiting, or altering by any means the figures, letters, words, or sign contained therein. Here's a question taken from the 1997 bar exam. A government employee was administratively charged with immorality for having an affair with B, a co-employee in the same office who believed him to be single. To exculpate himself, A testified that he was single and was willing to marry B. He induced C to testify, and C did testify that B was single. The truth, however, was that A had earlier married D, now a neighbor of C. Is A guilty of perjury? The answer, no, A is not guilty of perjury because the willful falsehood asserted by him is not material to the charge of immorality. Whether A is single or married, the charge of immorality against him as a government employee could proceed or prosper. In other words, A's civil status is not a defense to the charge of immorality, hence not a material matter that could influence the charge. Another question here. In falsification of public document, or documents rather, is it necessary that there be the idea of gain or intent to injure a third person? The answer, no. In falsification of public or official documents, it is not necessary that there be present the idea of gain or the intent to injure a third person, because in the falsification of document or falsification of public document, what is punished is the violation of public faith and the destruction of the truth as therein solemnly proclaimed. This was found in Gallios versus People, GR number 174730-37, February 9, 2011. Another question here. A counterfeited the signature of B, but what he entered in the statement of assets and liabilities of B are all true, since there was no damage to the government. Did he commit any crime? The answer, yes. In falsification of public document, it is immaterial whether or not the contents set forth therein were false. What is important is the fact that the signature of another was counterfeited. In a crime, falsification of public document, the principal thing punished is the violation of public faith and the destruction of the truth as therein solemnly proclaimed. Thus, intent to gain or injure is immaterial. Even more so, the gain or damage is not necessary. This was found in the case of Kaobang versus People, GR number L-62634, June 26, 1992. Here's another question. Can falsification be committed by omission? The answer, Yes, in the case of People versus Dizon, an assistant bookkeeper who, having brought several articles for which he signed several cheats, intentionally did not record in his personal account most of the said cheats and destroy them so that he could avoid paying the amount thereof, was held guilty of falsification by omission. Another question, is there a complex crime of estafa through falsification of a public document? The answer, none. The fraudulent gain obtained through deceit in estafa, in the commission of which a private document was falsified, is nothing more or less than the very damage caused by the falsification of such document. Here's another scenario. The Ombudsman placed petitioner Jose C. Miranda, then the mayor of Santiago City, Isabela, under preventive suspension for 6 months from 25th of July 1997 to 25th of January 1998 for alleged violation of the Code of Conduct and Ethical Standards for Public Officials and Employees. Subsequently, then Vice Mayor Amelita S. Navarro filed a complaint with the Office of the Ombudsman. Vice Mayor Navarro contended that Mayor Miranda committed the felony of usurpation of authority or official functions. Mayor Miranda asserted that he reassumed office on the advice of his lawyer and in good faith. He also averred that on the day he reassumed office, he received a memorandum from DILG Undersecretary Manuel Sanchez instructing him to vacate his office, and he immediately complied with the same. Notably, Mayor Miranda's counter-affidavit also stated that he left the mayoralty post after coercion by the Philippine National Police. May Mayor Miranda invoke good faith? The answer, no. The court is not persuaded by the posture of the petitioner that he reassumed office under an honest belief that he was no longer under preventive suspension. Petitioner's pretense cannot stand scrutiny. A petitioner's excuse for violating the order of the preventive suspension is too flimsy to merit even a side glance. He alleged that he merely followed the advice of his lawyer. If petitioner and his counsel had an iota of respect for the rule of law, they should have assailed the validity of the order of suspension in court instead of taking the law into their own hands. This case is found in Miranda versus Sandigan Bayan, GR number 154098, July 27, 2005. Here's another case. Petitioner Orzua was asked by his counsel to get a copy of the complaint from the Office of the Ombudsman. Petitioner told Oscar Perez, the law firm's messenger, that he feels uncomfortable asking for a copy of the complaint since he one of the respondents. Perez told petitioner that the latter can go there as Oscar Perez. At the Office of the Ombudsman, petitioner registered in the logbook as Oscar Perez. Loida Kahulugan gave him a copy of the complaint to which petitioner acknowledged as Oscar Perez. However, Loida learned that the person is not Oscar Perez, but in fact Cesario Orzua. Is the act of petitioner of using the name Oscar Perez a violation of the Section 1 of CA number 142? The answer, no. Petitioner's writing of the name Oscar Perez in an isolated transaction is not the act contemplated under Section 1 of CA number 142. The use of fictitious name or a different name belonging to another person in a single instance without any sign or indication that the user intends to be known by his name in addition to his real name from that day forth does not fall within the prohibition contained in CA number 142 as amended. Petitioner introduced himself in the office of the Ombudsman as Oscar Perez, which was not his own name, and he did so while merely serving the request of his lawyer to obtain a copy of the complaint in which the petitioner was a respondent. Hence, the use of Oscar Perez is not an alias name of petitioner. There is no evidence showing that he had used or was intending to use the name as his second name in addition to his real name. This case is found in Ursua, CA JR number 112170, April 10, 1996. And here's our another topic. It is about the Comprehensive Dangerous Drug Act. Here's another scenario and another question taken from 2007 bar exam. Tiburcio asked Anastasio to join their group for a session. Thinking that it was for a mahjong session, Anastasio agreed. Upon reaching Tiburcio's house, Anastasio discovered that it was actually a shabu session. At that precise time, the place was raided by the police and Anastasio was among those arrested. What crime can Anastasio be charged with, if any? Explain your answer. The answer is, Anastasio may not be charged of any crime. Section 7 of Republic Act number 9165 on the Comprehensive Dangerous Drugs of 2002 punishes employees and visitors of a den, dive, or resort where dangerous drugs are used in any form. But for a visitor of such place to commit the crime, it is a requisite that he is aware of the nature of the place as such and shall knowingly visit the same. These requisites are absent in the facts given. Here's another question. After receiving reliable information that Dan Tiong, a notorious drug smuggler, was arriving on PAL flight number PR181, the PNP Chief Inspector Samuel Gamboa formed a group of anti-drug agents. When Ong arrived at the airport, the group arrested him and seized his attaché case. Upon inspection inside the immigration holding area, the attaché case yielded 5 plastic bags of heroin weighing 500 grams. Chief Inspector Gamboa took the attaché case and boarded him in an unmarked car driven by PO3 Pipito Lorbes. On the way to Camp Crame and upon nearing White Plains Corner EDSA, Chief Inspector Gamboa ordered PO3 Lourdes to stop the car. They brought out the drugs from the case in the trunk and got 3 plastic sacks of heroin. They then told Ong to alight from the car. Ong left with the 2 remaining plastic sacks of heroin. Chief Inspector Gamboa advised him to keep silent and go home, which the latter did. Unknown to them, an NBI team of agents had been following them and witnessed the transaction. They arrested Chief Inspector Gamboa and PO3 Lorbes. Meanwhile, another NBI team followed Ong and likewise arrested him. All of them were later charged. What are their respective criminal liabilities? This was asked in 2006 bar exam. And here's the answer. Chief Inspector Gamboa and PO3 Pipito Lorbes, who conspired in taking the attaché case, are liable for the following crimes defined under RA 9165. Letter A. Section 27 for misappropriation or failure to account for the confiscated or seized dangerous drugs. B. Section 4 in relation to Section 3 EE for their acts as protector coddler of Dante Ong who imported drugs. In addition, by allowing Ong to escape prosecution for illegal importation or illegal transportation of dangerous drugs, where the penalty is life imprisonment to death. They are also liable for qualified bribery under Article 211-A of the Revised Penal Code. With respect to Dante Ong, he is guilty of illegal importation of dangerous drugs under Section 4 RA 9165 if PR 181 is an international flight. If PR 181 is a domestic flight, he is liable for violation of Section 5 RA 9165 for illegal transportation of dangerous drugs. And here's another question. Who are subject to confirmatory drug test under Section 15 of RA 9165? The answer, a person apprehended or arrested who are to be subject of confirmatory drug test cannot literally mean any person apprehended or arrested for a crime. The phrase must be read in context and understood in consonance with RA 9165. Section 15 comprehends person arrested or apprehended for unlawful acts listed in Article 2 of the law. In this case, the accused appellant was arrested in the alleged act of extortion. Hence, the drug test conducted to him, despite his objection, is rendered illegal and is therefore inadmissible. Since the drug test was the only basis for his conviction, the court ordered the acquittal of the accused. This is found in De La Cruz versus People, GR number 200748, July 23, 2014. Another question here, is coordination with the PDEA an indispensable requirement before police authorities may carry out a buy-bust operation? The answer, coordination with the PDEA is not an indispensable requirement before police authorities may carry out a buy-bust operation. Well, it is true that Republic Act number 9165 requires the NBI, PNP, and the Bureau of Customs to maintain close coordination with the PDEA and all drugs-related matters. The provision does not make PDEA's participation a condition sine qua non for every buy-bust operation. A buy-bust operation is just a form of an in flagrante arrest, sanctioned by Section 5, Rule 113 of the Rules of the Court, which police authorities may rightfully resort to in apprehending violators of Republic Act number 9165 in support of the PDEA. A buy-bust operation is not invalidated by mere coordination with the PDEA. So this is found in People versus Balakot, JR number 206366, August 13, 2014. A and his fiancée, B, were walking in the plaza while they meet up a group of policemen who had earlier been tipped off that A was in possession of prohibited drugs. Upon seeing the policemen and sensing that they were after him, A handed a sachet containing shabu to his fiancée, B, telling her to hide it in her handbag. The policeman saw B placing the sachet inside her handbag. If B was unaware that A was a drug user or pusher, or that what was inside the sachet given to her was shabu, is she nonetheless liable under the Dangerous Drug Act? This was asked in 2002 bar exam. The answer, no, B will not be criminally liable because she is unaware that A was a drug user or a pusher, or of the content of the sachet handed to her by A, and therefore the criminal intent to possess the drug in violation of the Dangerous Drugs Act is absent. There would be no basis to impute criminal liability to her in the absence of animus possidendi. And here's another question from 2005 bar exam. Ubi Juan is suspected to have in his possession an unspecified amount of methamphetamine hydrochloride or shabu. An entrapment operation was conducted by police officers, resulting in his arrest following the discovery of 100 grams of the said dangerous drugs in his possession. He was subjected to a drug test and was found positive for the use of marijuana, another dangerous drug. He was subsequently charged with 2 crimes: violation for the possession of shabu and violation for the use of marijuana. Are the charges proper so as not to be sentenced to death? Ubi Juan offers to plead guilty to lesser offense. Can he do so, and why? Explain. This was asked in 2005 bar exam. The answer: no, the use of dangerous drugs is not committed when Ubi Juan was also found to have in his possession another dangerous drug. Ubi Juan cannot plead guilty to a lower offense as it is prohibited under the law. Section 23 of RA number 9165 provides that any person charged under any possession of his act, regardless of the imposability or imposable penalty, shall not be allowed to prevail of the provision on plea bargaining. Here's another question. What is the primary purpose of establishing the chain of custody? And the answer: compliance with the chain of custody requirement ensures that integrity of confiscated, seized, and or surrendered drugs and or drug paraphernalia in 4 aspects. Number 1, the nature of the substance or items seized. Number 2, the quantity or example like weight of the substance or items seized. Number 3, the relation of the substances or items seized to the incident allegedly causing their seizure. And number 4, the relation of the substances or items seized to the person alleged to have been in possession of or peddling them. Compliance with these requirements forecloses opportunities for planting, contaminating, or tampering of evidence in any manner. By failing to establish identity of corpus delicti indicates a failure to establish an element of the offense of illegal sale of dangerous drugs. It follows that this non-compliance suffices as a ground for acquittal. In both illegal sale and illegal possession of prohibited drugs, conviction cannot be sustained if there is a persistent doubt on the identity of the drug. The identity of the prohibited drug must be established with moral certainty. Apart from showing that the elements of possession or sale are present, the fact that the substance illegally possessed and sold in the first place is the same substance offered in court as exhibit must likewise be established with the same degree of certitude as that needed to sustain a guilty verdict. This scenario is found in People versus De La Cruz, JR number 205821, October 1, 2014. The chain of custody rule requires that the admission of an exhibit be preceded by evidence sufficient to support a finding that the matter in question is what the proponent claims it to be. It would include testimony about every link in the chain from the moment the item was picked up to the time it is offered into evidence, in such a way that every person who touched the exhibit would describe how and from whom it was received, where it was, and what happened to it while in the witnessed possession. The condition in which it was received and the condition in which it was delivered to the next link in the chain. Thus, if the prosecution failed to present the testimony of the police inspector who had the only keys to the evidence locker where the sachet of shabu, the unbroken chain of custody was not established and the accused must be acquitted. This is found in People versus Abitong, GR number 209785, June 4, 2014. Here's another question here. May the defense of non-compliance to chain of custody rule be raised for the first time on appeal? The answer, when an accused raises the issue of non-compliance by the police officers with Section 21 of the IRR of RA 9165, particularly the lack of physical inventory of the seized specimen and the non-taking of photograph thereof on appeal after the CA rendered the decision, the court must uphold his conviction. Cabrera should have raised the said issue before the trial court. Truly, objection to evidence cannot be raised for the first time on appeal. When a party desires the court to reject the evidence offered, he must so state in the form of an objection. Without such objection, he cannot raise the question for the first time on appeal. This was taken from People versus Cabrera, GR number 190175, November 12, 2014. Another question, is the delay in the turnover of the dangerous drugs to the PNP Crime Laboratory decisive in the prosecution for violation of Dangerous Drugs Act? The answer, yes. When there was delay in the turnover of the corpus delicti of the PNP Crime Laboratory, as it was alleged that the date the illegal sachet was seized falls on a Friday and therefore the PNP Crime Laboratory was closed. It appears that said date falls on Wednesday, not on Friday. Conviction must be immediately set aside. It must be emphasized that in criminal prosecutions involving illegal drugs and presentation of drugs, which constitutes the corpus delicti of the crime, calls for necessity of proving with criminal certainty that they are the same seized items. This is found in People versus Somili, GR number 212160, February 4, 2015. Another question, is the presentation of an informant in an illegal drugs case essential for the conviction of an accused? The answer, no, the presentation of an informant in an illegal drugs case is not essential for the conviction, nor is it indispensable for a successful prosecution, because his testimony would be merely corroborative and cumulative. The informant's testimony is not needed if the sale of the illegal drugs has been adequately proven by the prosecution. This is People versus Amansek, 662 SCRA 574, December 14, 2011. Another question, based on an information from an informant, a bypass operation was constituted. The police officers occupied different positions in order to observe their informant, who was also the pursuer buyer. The transaction between the informant and the accused Andaya was made, and thereafter the prearranged signal signifying consummation of the transaction was given. The police officers approached the two and arrested them. The accused was charged with illegal sale of drugs, but he contends that the non-presentation during the trial of the confidential informant, who was the pursuer buyer, was adverse to the prosecution, indicating that his guilt was not proved beyond reasonable doubt. is the presentation of informant necessary in the prosecution for illegal sale of dangerous drugs? The answer, as a rule, it is not necessary for the state to present the informant during the trial for illegal sale of dangerous drugs. However, in this case, the confidential informant was not a police officer, but he was designated to be the poseur buyer himself. The state did not present the confidential informant poseur buyer during the trial to describe how exactly the transaction between him and Andaya had taken place. There would have been no issue against failure to present the confidential informant poseur buyer, except that none of the members of the bypass team had directly witnessed the transaction, if any, between Andaya and the poseur buyer, due to their being positioned at a distance of the moment of the supposed transaction. The presentation of the confidential informants as witness for the prosecution in those instances could be excused because there were poseur buyers who directly incriminated the accused. In this case, however, it was different because the poseur buyer and the confidential informant were one and the same. Without the poseur buyer's testimony, the state did not credibly incriminate Andaya. So that case is found in People versus Andaya, JR number 183700, October 13, 2014. Another question, is the non-presentation of the forensic chemist in illegal drugs case a sufficient cause for acquittal? The answer, no. The court has already ruled in a number of cases that non-presentation of the forensic chemist in illegal drugs cases is an insufficient cause for acquittal. Thus, it is of no moment that forensic chemist officer Mangalip was not presented as witness. The non-presentation as witness of other persons who had custody to the illegal drugs is not a crucial point against the prosecution. It is the prosecution which has the discretion as to how to present its case, and it has the right to choose whom it wishes to present as witnesses. What is important is that the integrity and evidentiary value of the seized drugs are properly preserved. This is found in People versus Fondales Jr., 680 SCRA 181, September 5, 2012. Another question here from 2012 bar exam. A police officer surreptitiously placed a marijuana stick in a student's pocket and then arrested him for possession of marijuana cigarette. What crime can the police officer be charged with? The answer, number 1, none, as it is a case of entrapment. Number 2, unlawful arrest. Number 3, incriminating an innocent person. Number 4, complex crime of incriminating an innocent person with unlawful arrest. Note that the correct answer is not included in the choices because the correct answer really is planting of evidence. In Section 29 of RA 9165, the Comprehensive Dangerous Drugs Act of 2002, specifically punishes the act of planting dangerous drugs. Section 29 provides that any person who is found guilty of planting any dangerous drugs and or controlled precursor and essential chemical, regardless of quantity and purity, shall suffer the penalty of death. Section 3cc of RA 9165 defines planting of evidence as the willful act of any person of maliciously and surreptitiously inserting, placing, adding, or attaching directly or indirectly through any overt or covert act whatever quantity of any dangerous drugs and or controlled precursor and essential chemical in person, house, effects, or in the immediate vicinity of an innocent individual for the purpose of implicating, incriminating, or imputing the commission of any violation of RA 9165. Okay, here's another scenario. Two vehicles were suspected to be used for transportation of dangerous drugs. The Starex van, driven by Mayor Mitra, was able to pass the checkpoint. However, the ambulance driven by Morelia was stopped, for it was noticed that there were several sacks inside the van. Upon inquiry, Morelia said that the sacks contained Nara wooden tiles, but the police officers requested for further inspection, where it was noticed that white crystalline granules were scattered on the floor. At the request of the police officers to open the sacks, Morelia said that he was with the Mayor Mitra to let him pass. Upon inspection, the contents of the sacks turned out to be sacks of shabu. It was also found that the van driven by Mayor Mitra contains the same. Accused was charged with illegal transport of dangerous drugs. Morelia contends that his mere act of driving a vehicle containing dangerous drugs is not sufficient to convict him. Is his contention correct? The answer, no. Mere act of driving is sufficient to convict Morelia of the crime charge. Transport, as used under the Dangerous Drugs Act, means to carry or convey from one place to another. It was well established during the trial that Morelia was driving the ambulance following the lead of Mayor Mitra, who was driving a Starex van going to Manila. The very act of transporting drugs or shabu is malum prohibitum, since it is punished as an offense under a special law. The fact of transportation of the sacks containing dangerous drugs need not be accompanied by proof of criminal intent, motive, or knowledge. This was found in People v. Morelia, JR number 189833, February 5, 2014. Here's another question. PO1 Reyes and PO1 Pastor, both wearing civilian clothes, were conducting anti-drug surveillance operations. While they were in front of Sari-Sari store, accused Lilo approached them and asked, "Gusto mong umiskor ng shabu?" PO1 Reyes replied, "Bakit? Meron ka?" Lilo then brought out 2 plastic bags containing shabu and told the police officers, dos or 200 pesos lang ang isa. Upon hearing this, the police officers introduced themselves as cops. PO1 Reyes immediately arrested Lilo, and a laboratory examination was conducted but found the discovered items positive for shabu, a dangerous drugs. And is there a crime committed even though the sale of illegal drugs was not consummated? The answer, yes. The crime committed was attempted illegal sale of drugs, punishable under Section 26B of RA 9165. The elements necessary for the prosecution of illegal sale of drugs are, number 1, the identity of the buyer and seller. Number 2, the object and the consideration. Number 3, the delivery of the things sold and the payment. And the policemen were the pusher buyers and the appellant was the seller. The substance contained in the plastic sachet which were found to be positive for shabu as the object and the consideration, which is 200 pesos for each sachet, was made known by the appellant. However, the sale was interrupted when the pusher buyer introduced himself to the appellant. Hence, the crime was not consummated. The appellant already commenced by overt act the omission of the intended crime by showing the substance to both of the policemen, but did not perform all the acts of execution which would produce such crime by reason of such cause or accident other than his own spontaneous desistance. Such cause or accident when the policemen introduced themselves and the sale was immediately aborted. Hence, appellant is guilty of attempted sale of dangerous drugs. This is found in People versus Lilo, GR number 192235, July 6, 2011. And our next topic is crimes against public morals. Here's a question. X, an 11-year-old girl, had sexual intercourse with her 18-year-old boyfriend Y. They performed the act in a secluded, vacant lot. Unknown to them, there was a roving policeman at that time. Hence, they were arrested. What crime did they commit? The answer, the sexual intercourse with a girl constitutes statutory rape. Though the act was carried out in a public place, criminal liability for grave scandal cannot be incurred. Note, the highly scandalous conduct should not fall within any other articles of RPC. Thus, this article provides for a crime of last resort. And here's another title, Crimes Committed by Public Officers. Another question here. The public prosecutor has to render his resolution in a case filed before their office. While the investigating public prosecutor was already drafting his resolution, the respondent in the said case arrived. A closed-door talk took place between the two, wherein the respondent offered the public prosecutor 2 million pesos in exchange for dismissal of the case filed against the respondent. The public prosecutor accepted the 2 million. Later, by reason of the bribe money given to him, the prosecutor issued a resolution dismissing the said case for lack of probable cause. Letter A, the question, what crime or crimes is or are committed by the public prosecutor? The answer, the public prosecutor is liable for direct bribery under Article 210. First, he is a public officer. Second, the said public prosecutor accepted a bribe money in the amount of 2 million in connection with the performance of the criminal act which has a connection with his official function. Hence, he is liable for direct bribery. The public prosecutor is also liable for dereliction of duty in the prosecution of offenses under Article 208 by reason of the 2 million given to him by the respondent. The public prosecutor actually rendered the said resolution dismissing the case despite his knowledge that the offender had actually committed the crime. He is a public officer who has the duty to prosecute, and he knows the commission of the crime. Yet, he did not cause the prosecution of the offender. He did so with malice and deliberate intent to favor the violator of the law because of the bribe money given to him. So, in this case, the public prosecutor is liable for 2 crimes. Number 1, direct bribery. Number 2, dereliction of duty in the prosecution of offenses. And letter B, here's a question. Without direct bribery, dereliction of duty in the prosecution of offenses will not be committed. Are you going to complex these crimes, considering that one is a necessary means to commit the other? The answer, no. Article 210 prohibits the complexity of the crimes. Under Article 210, the liability of direct bribery shall be in addition to the liability attaching to the public officer for the commission of the crime agreed upon. Another question. X, a police officer, was conducting a patrol in an area when he noticed a man hiding behind a mango tree. He saw that the man was intently looking at the house across the street. When the gate of the house opened, just as when a car was about to leave the house, the man immediately boarded his motorcycle, went near the said gate, and thereafter repeatedly shot the driver of the car, which resulted to instant death of the latter. The man in the motorcycle got away. The police officer chased him and was able to arrest him. However, the man in the motorcycle said, "If you allow me to leave, I'll give you 500,000. The police officer accepted the money and allowed him to leave. What crime, if any, is committed by the said police officer? The police officer is liable for qualified bribery under Article 211-A. The police officer is a public officer in charge with the enforcement of the law, and he resisted to arrest a person who has committed a crime punishable by reclusion perpetua and or death. The police officer did not arrest the said man because of the 500,000 given to him." Another scenario here, X has been appointed as the new head of LTO. During his first day in office, Y visited him. Y talked to X, and after their exchange of pleasantries, the visitor left. When Y left, he also left a small gift box on top of the table of X containing a key to a new car and a note that the car is in the parking space at the basement of the building. X went to the basement and used the car. Is X liable for any crime? The answer, X is liable for indirect bribery under 211 because he is a public officer and he accepts a gift by reason of his office. Y, the visitor, does not require him to do anything. It was merely given to him because he was newly appointed as the LTO chief. His acceptance brings about the consummation of indirect bribery. And another question here, in the above-mentioned cases, what is or what are the criminal liability of the person giving the bribe? The answer, they are liable for corruption of public officials under Article 212. It is committed by any person who shall have made the offers or promises or given the gifts of presents in the consummation of direct or indirect bribery. Another case here, taken from 1990 bar exam. Melda, who is the private secretary of Judge Tulits Naya, was persuaded by the litigant Jumbo to have his case calendared as early as possible for a consideration of 500,000. May she be held criminally liable for the accommodation? The answer would be qualified by the implication of the phrase or to have his case calendared as early as possible. If the phrase is interpreted as an unjust act and in violation of the rule to give priority to the older cases, then she would be liable under direct bribery for an act which does not constitute a crime but is unjust. He may also be held liable under Section 3E of RA 3019, the Anti-Graft and Corrupt Practices Act as amended. X, giving any private party any unwarranted benefits. If you interpret the phrase as a non-violation of the rules and regulations, then he can only be held liable for direct bribery. Another question here from Bar 1990 exam. What will be the criminal liability of Milda if she volunteered to persuade Judge Tolitz Naya to rule in Jumbo's favor without asking any consideration? The answer, Milda is not criminally liable because the act of volunteering to persuade is not a criminal act. It is the act of persuading that is considered a criminal act. The act does not fall under Article 210 of the Revised Penal Code on direct bribery, nor does it fall under Article 211 of the RPC on indirect bribery. Neither does it fall under the Anti-Graft and Corrupt Practices Act, Section 3A of RA 3019. refers to act of persuading another public official to violate rules and regulations. Another case here, Don Gabeto, a philanthropist, offered to fund several projects of the mayor. He opened an account in the mayor's name and regularly deposited various amounts ranging from 500,000 pesos to 1 million pesos. From this account, the mayor withdrew and used the money for constructing feeder roads, barangay clinics, repairing schools, and for all other municipal projects. It was subsequently discovered that Don Gabeto was actually a witting operator, and the amounts he deposited were proceeds from his witting operations. What crimes were committed? Who are criminally liable, and explain. This was taken from the bar 2005 exam. The answer, Don Gabeto is liable for corruption of public officials under Article 212 of the Revised Penal Code for having given the amounts that were deposited in an account which he opened in the mayor's name for no reason, but the public position or office held by the mayor. The mayor is liable for indirect bribery for accepting such money deposited in his accounts by using them when they were given to him for no other reason except for his public position as a mayor and violation of Republic Act 6713 or the Code of Conduct and Ethical Standards for Public Officials and Employees, and for receiving such gifts from someone who may be affected by the functions of his office. Another question here. Accused Hernandez served a mission order against National. There were complaints against Aoyagi for being suspected as a Yakuza big boss, a drug dependent, and an overstaying alien. To prove his innocence, Aoyagi gave his passport to Hernandez as a guarantee to his appearance at a bid hearing in a meeting outside the bid office, and accused Hernandez allegedly demand 1 million pesos for the return of Aoyagi's passport. Because of such demand, an entrapment operation was made. In a meeting to return Aoyagi's passport, Hernandez immediately left after the payment was made to his co-accused. Is the act of bribery committed even though his act of returning the passport is not a crime? The answer? Yes. The second kind of direct bribery was committed by the accused. Accused was convicted under the second kind of the direct bribery, which contained the following elements. Number 1. The offender was a public officer. Number 2, who received the gifts or presents personally or through another. Number 3, in consideration of an act that did not constitute a crime. Number 4, that the act related to the exercise of official duties. The passport confiscated by the accused was supposed to have been voluntarily given to Takao Aoyagi as a guarantee to appear at the bid office. However, Takao Aoyagi had to negotiate for the retrieval of the passport during the meetings held outside the bid, which was not a standard operating procedure to officially return withheld passport in such locations. It can readily be inferred that the accused had an ulterior motive for withholding the passport for some time despite the absence of any legal purposes. This case is found in Acejas III versus People, JR number 156643, June 27, 2007. Torres was a principal of high school. The school's collection and disbursing officer prepared 3 checks representing the teachers, the employees' salaries, and the other compensation for the months of January to March 1994 in the total amount of 196,654.54 cents. Torres signed the 3 checks and encashed them. However, he never returned to the school to deliver the money and contends that a group of armed men took the encashed checks from him. The RTC convicted Torres for the crime of malversation of public funds. He appealed his case. May Torres be properly convicted based on the information which clearly charged him with intentional malversation and not malversation through negligence, which was the actual nature of the malversation for which he was convicted by the RTC? The answer, yes, malversation may be committed either through a positive act of misappropriation of public funds or property or passively through negligence. To sustain a charge of malversation, there must either be criminal intent or criminal negligence, and while the prevailing facts of a case may not show that deceit attended the commission of the offense, it will not include the reception of evidence to prove the existence of negligence, because both are equally punishable under Article 217 of the RPC, even when the information charges willful malversation. Conviction for malversation through negligence may still be adjudged if the evidence ultimately proves the mode of commission of the offense. This case is found in Torres versus People, JR number 184908, July 7, 2013. Here's another case. Mayor Cantos was assigned to supervise the disbursement of funds for the PSG personnel and to perform other financial duties. He placed the money in a duffel bag and kept it inside the steel cabinet in his office. One day, he inspected the steel cabinet and discovered that the duffel bag, which contained the money, was missing. He was found liable by the RTC for malversation. Major Cantos contends that he could not be liable for malversation for mere failure to produce the funds does not necessarily mean that he misappropriated the same. Is he liable for malversation of public funds? The answer, yes. The presumption in Article 217 of the Revised Penal Code as amended states that the failure of the public officer to have duly forthcoming any public funds or property with which he is chargeable upon demand by any duly authorized officer is prima facie evidence that he has put such missing fund or property to personal use. The presumption is, of course, rebuttable. Accordingly, if petitioner is able to present adequate evidence that can nullify any likelihood that he put the funds or property to personal use, then that presumption would be an end and the prima facie case is effectively negated. In this case, however, petitioner failed to overcome this prima facie evidence of guilt. And so this can be found in the case of Cantos versus People, GR number 184908, July 3, 2013. Here's last two cases from this part 4 of our criminal law. Elizabeth is the municipal treasurer of Masinloc, Zambales. On January 10, 1994, he received as municipal treasurer from the Department of Public Works and Highways the amount of 100,000 pesos known as the Fund for Construction, Rehabilitation, Betterment, and Improvement for the concreting barangay of Phoenix Road located in Masinloc, Zambales in project undertaken and proposal of the barangay captain, informed that the fund was already exhausted while the concreting of Barangay Phoenix Road remained unfinished. A representative of the Commission on Audit conducted a spot audit of Elizabeth, who failed to account for the 100,000 pesos CRBI fund. Elizabeth, who was charged with malversation of public funds, was acquitted by the Sandigan Bayang of that charge but was nevertheless convicted in the same criminal case for illegal use of public funds. On appeal, Elizabeth argued that her conviction was erroneous and, as she applied for for amount of 50,000 for a public purpose without violating any law or ordinance appropriating the said amount for any specific purpose. The absence of such law or ordinance was in fact established. Is the contention of Elizabeth legally tenable? Explain. This was taken from 1996 bar question. The answer, Elizabeth's contention that her conviction for illegal use of public funds, technical malversation was erroneous, is legally tenable because she was charged for malversation of public funds under Article 217 of the Revised Penal Code but was convicted for illegal use of public funds, which is defined and punished under Article 220 of said code. A public officer charged with malversation may not be validly convicted of illegal use of public funds or technical malversation because the latter crime is not necessarily included, nor does it necessarily include the crime of malversation. From the facts, there is no showing that there is a law or ordinance appropriating the amount to a specific public purpose. As a matter of fact, the problem categorically states that the absence of such law or ordinance was in fact established. So, procedurally and substantially, the Sandigan Bayan's decision suffers from serious infirmity. Here's the last question for this part 4 of our review. COA Auditor Florence L. Pagirigan examined the year-end reports involving the municipal officials of Alfonso Lista Ifugao, and during the course of her examination, she came across a disbursement voucher of 101,736 pesos prepared for Lumawig, a former mayor of the municipality, as cash advance for the payment of freight and other cargo charges for 12 units of motorcycles supposed to be donated to the municipality. Despite the full efforts of COA, letters informing him of the unliquidated cash advance were not sent because of the address of the same cannot be obtained. Lumawig admitted having obtained the cash advance of 101,736 pesos during his incumbency as municipal mayor of Alfonso Lista, Ifugao. This amount was intended for the payment of freight and insurance coverage of 12 units of motorcycles to be donated to the municipality by the city of Manila. However, instead of motorcycles, he was able to secure 2 buses and 5 patrol cars. He claimed that it never came to his mind to settle or liquidate the amount advanced since the vehicles were already turned over to the municipality. Can Lumawig be held liable for the crime of failure of accountable officer to render account? The answer, yes. Lumawig can be held liable with the crime of failure to accountable officer to render account under Article 218. To be liable for such crime, the following requisites must be present. Number 1, that the offender is a public officer, whether in the service or separated therefrom. Number 2, that he must be an accountable officer for public funds or property. Number 3, that he is required by law or regulation to render accounts to the Commission on Audits or to the provincial auditor. Number 4, that he fails to do so for a period of 2 months after such accounts should be rendered. The law does not state that there must first be a demand for an officer to be held liable. Therefore, he is liable for such crime. And this is found in People versus Lumawig, JR number 16680, July 7, 2014. And that would be all for our part 4 of this criminal law, and I'll be back for the part 5. Thank you so much for listening. I do hope I contributed something to help your criminal law review for the Philippine bar exam.
I am doing this reading or audio to help also myself as I am struggling with my focus in reviewing the bar exam. I really find it hard to study, especially reading these notes, so I decided to make this video so that even if I am doing something or I am in public places, I still be reviewing the bar in my earphones. If you want also a copy of my reading audios, please send me a message, or if you want me to read some other bar reviewers in my email ad, sender5681@gmail.com, or to my Facebook page, sender5681. It would be a pleasure to help others while I am reviewing for the bar exam, and I am so happy to share these things to my fellow bar candidates. Thank you so much, and God bless.